that have come out in the last 6 months since our presentation in January that I thought would be of interest. And really, there's so much stuff out there that it's hard to keep up with, especially for a 30-minute presentation. So I'll do the overview. Sonia Salas is going to do an update on Title IX, and Dan Murphy has been kind enough to give us an update on the Pregnancy Act rules. So in terms of my overview, I'll start off with the Supreme Court cases, and then I'll hit some 11th Circuit updates. And then there's a few legislative updates, which probably everybody knows at this point, and then kind of what to keep your eye on moving into the second half of 2024 and into 25. I think an important case that came down but didn't get a lot of attention in Georgia media, not necessarily, is a National Labor Relations Board decision that allowed for the Dartmouth men's college basketball team to unionize. Now, there's a lot of irony in that. Dartmouth basketball, and then they would be considered employees at an Ivy League school. But there you have it. Dartmouth is moving forward with a, actually, and I just saw in the news this morning where the men's basketball team is now suing the university because they failed to engage in negotiations with them to become a union. So they got another lawsuit coming, so there'll be more to talk about if that's all true, what I'm seeing in the press. The gist of this case was, even though, you know, an Ivy League school, you don't get a scholarship, right? It's all needs-based. So, but they still found, even though there's no scholarship involved, there's enough control of the university and there's enough benefit to the student athletes that they could unionize and move forward. That's decisions on appeal. And then I also just mentioned that there is a supposedly another lawsuit coming over this. We've all probably heard about this case, having practiced anywhere in employment law, is the Supreme Court case, the Muldrow decision. And this makes a sea change in what is considered to be an adverse action under Title IX discrimination claims. Basically, the plaintiff was a investigator who served in that role for years, and then she got a new supervisor, and this is probably a lesson for all new supervisors. She not only got changed out of being in this investigative role, which she found prestigious, but then she had to do like her schedule change as well. So due to those changes, so the police department argued that that wasn't an adverse action because she still retained her job. You know, her salary didn't change, her benefits didn't change. So it wasn't a serious and material change under then existing law. But the Supreme Court took a look at that, and that judge-made law was struck down by the Supreme Court, saying there's never any standard for serious and material change. She won at both the district court and the 8th Circuit, and then, of course, when that gets appealed and the Supreme Court takes it, something's going to happen against the employer in that situation. That's exactly what happened. I think to kind of summarize where Muldrow leads us, and not too surprisingly, is that there's going to be a lower bar. Obviously, some harm is now the standard for an adverse action. So defense attorneys out there looking to file a motion to dismiss, a motion for summary judgment on adverse action, I think you're going to have an uphill struggle on that one. And there's another case in the 11th Circuit that picks up on this I'll present on shortly. Here's one that is an interesting case that, you know, it's kind of like a tidal wave that comes very slowly at you. And this is the Looper Bright Industries versus Ramado. This has to deal with a Commerce Department regulation that required essentially fishermen, and they picked on the wrong people. They're fishermen. Especially don't mess with New England fishermen. That required them to pay for their essentially a person to come on board their boat to make sure that they weren't overfishing, they were complying with the regulations of the Commerce Department, right? So the fishermen, filed suit, and this thing worked its way up to the Supreme Court. And essentially what the Supreme Court did was overturn a lawsuit called Chevron. And for years, I mean, if anyone took an administrative law class in law school, you learned about Chevron deference. And, so that's basically where the courts would defer to a federal agency's rules because they were the experts, right? And that had a powerful effect on lawsuits because the federal rule had the force of law, and the judge had to give it deference. So they're already way out in front of the gate there. So this strikes that down, this Looper case, and it creates all kinds of ripple effects in our practice. Sonia's going to present on Title IX, and of course those new 2024 rules that are mostly out. And certainly not applicable in the 11th Circuit. You'll see more of this, I think, challenging of the federal rules by plaintiffs. I cite the one case here, I got kind of curious about how many people are already citing the Looper. Looper came out June 28th, and already you see plaintiffs and court decisions citing to Looper that whether a federal reg is applicable here and what kind of deference it gets. And here's one I cited, the Arkansas versus the DOE, that's in a Missouri court, as I recall, federal court. And that district court cited to Looper in its opinion in striking down the Title IX regs. Didn't take long, did it? This is a First Amendment case, Linkey versus Freed. Has a companion case that both went up to the Supreme Court. And this had to deal with public officials and social media, and they go hand in hand, right? Well, this case had to deal with when does a public official's social media account amount to a public action, right? So when is a public official, either your employee or elected official, and when do you cross that line out of being just a private citizen with a Facebook account to being, a politician or a public official? Well, this case tries to sort that out, but I don't think we're going to have a whole lot of clarity moving forward because it's first of all, it's First Amendment, extremely complex area. And, so public officials have a First Amendment right to speak out as well, right? And I guess the takeaway from this case is that public officials, public employees, if they really want to keep their Facebook accounts private, then they need to set up a whole different Facebook account and keep that non-work related, okay? That's probably the safest way to go. And that's pretty hard to do because people know you in the community, and they may post something to your Facebook account even though you don't want them to, right? But I think this decision highlights a difficulty in just any public official, public employee operating in social media, because it's very difficult to sort out exactly when things become public and when it's private, even though you're trying to keep it private. In this case, Linkey had to deal with a city manager blocking somebody from posting on his Facebook account because he thought it was private. This is a battle of the contracts case. This is definitely a school board, school district type of case. So if you're in school and college law, college law, you're not going to find that interesting, other than maybe the sovereign immunity as it applies to a contract. This is one of these really, school board law can get really wonky, and this is one of the areas it can. And this has to deal with a teacher who was issued a contract by state law, and I put the statute up there. So he has to be issued a contract by May 15th, but when the school district issues that contract, the teacher has to sign it within 10 days. So, and the contract issued has to be complete per the statute. Can't be blank, it has to say the salary, job title, all that good stuff. Well, Tibbetts, who's a teacher, claimed that he was not issued a valid contract, so therefore the school district can't claim sovereign immunity barred his claim. So Tibbetts says, you issued me a contract, to me, blanks in it. So I never got a contract. So I'm automatically renewed on May 15th. School district says, no, we issued a valid contract, but you didn't sign it in 10 days, so you don't have the contract. When we have sovereign immunity, you can't sue us. So this thing ping-ponged around. It went through trial court, and trial court granted summary judgment to the school district. And then the Court of Appeals overturned that, said no, that contract was not complete, so there was no contract. He's automatically renewed, so Worth County School District, you got a new employee. And then the Supreme Court came back in and upheld summary judgment in this case, saying the contract was fine, he didn't sign it in time, so sovereign immunity bars his claim. When I first saw this case, I guess last spring, my first impression was the way school districts avoid people claiming they have a contract with you is that on or before May 15th, you got to give them your notice of non-renewal, excuse me. So if you give them that notice, then you're off the hook. But that didn't happen either in this case. So that, to me, would have been the easy way out of this, but that didn't happen. So here's your Worth County case. So sovereign immunity can bar a teacher contract case if the teacher never signs it. This is a case that comes out of the 11th Circuit, and it has to deal with a Head Start program head who is suing the Board of Regents under a federal claim and a state claim. Federal claim is the False Claims Act, and the state law claim is the Georgia Whistleblower Act, okay? And I put this case in here really, I guess, for my edification, but both the district court and the 11th Circuit found that 11th Amendment immunity, they say that it's not abrogated for a False Claims Act or for the Georgia Whistleblower Act. So you can't sue the Board of Regents based on 11th Amendment sovereign immunity. I did not know that. Maybe someone who's practiced in that area more than I have. This is a case that Sonia's going to hit on, but I wanted to touch on because it's so important. It's like one of the major cases in a long time, especially in the 11th Circuit, and now at the Supreme Court. This is the challenge by the states in the 11th Circuit, Georgia, Alabama, over those Title IX regs, right? And Sonia's going to get more detail on it. I just want to point out two things about this case that I found interesting, at least at this point. Okay, so these states, they sue the federal government over the Title IX regs 2024. They sue them in the Northern District of Alabama. Now, my first impression is, wow, that's kind of interesting. Why do they sue there? But my sense, and I'm just me talking here, my sense is that they sued them there because they thought that they would get a favorable outcome. They would get the injunction that they sought, right? Maybe Northern District of Alabama might be pretty conservative. Well, that's not what happened. They had a judge, and the judge was appointed by Donald Trump, um, but the judge denied their injunction, and that happened like in late July, I think. Um, and they quickly appealed that to the 11th Circuit, who quickly granted the appeal and then put an administrative injunction over the Title IX regs. I mean, maybe you guys have seen an administrative injunction put in place immediately by the 11th Circuit over all those regs, all of them, not just the challenge ones. So I just found it, just noting some interesting things in a case that I saw when I was looking at it. Oh, there's so many slides on this because I originally thought I was going to do more on it, but now Sonia's going to do it. So here's an interesting case. It has to deal with a disability case over a medical school student at Morehouse. This is a medical student who apparently didn't do very well, and he had a disability, and he said that the medical school needed to accommodate him in note-taking. And this winds up being, but the case isn't entirely clear about what the accommodation the medical school ended up providing for the note-taking that satisfied the school's requirement of providing a reasonable accommodation. Apparently, during his first couple of years in medical school, the medical school's like, nah, you don't need any note-taking assistance. And then like in his third year, they provided the assistance. And the 11th Circuit found that that was enough. It seems to me like maybe a bit of a delayed accommodation, but he had attention deficit disorder. And but this trial court granted the motion for summary judgment, and the 11th Circuit affirmed that accommodation was provided. Here's that case that I was talking about earlier about Muldrow. This is one where a school bus driver sued for religious and Title VII claims. And anyway, he was had a change in work schedule where before he didn't have to work on a Sunday, and now he did. As a school bus driver, sometimes there's weekend trips, sports events that they can drive on. He said that requiring him to drive on the Sabbath was a violation, and he sued, obviously, and the school district moved to dismiss it because it was an adverse event. The guy was always a school bus driver, and this is one of the more recent cases out there with Muldrow holding that an adverse event just has to be some harm. It doesn't have to be, so it's a low showing for the school bus driver, and the case is moving on. There's a couple more like these in the 11th Circuit that just came out. Renderly, you may have heard of this plaintiff in the news. This was the Cobb County teacher who was terminated for reading a book to her elementary school class, or allowing the book to be read, called The Shadow of Purple is the name of the book. And the school district claimed that the book violated its policies over divisive, controversial topics. The case went to a termination hearing, I think last year. Yeah, it's a couple-day hearing, and so she is now the panel didn't want to terminate, and then the board said to terminate her, so she's terminated. She appealed that to the DOE and the Superior Court, and she's lost at both levels. So this is kind of an update on an interesting case. She has now filed a federal lawsuit against Cobb County Schools. And I put the case number there. She's claiming lack of due process and other things in her federal court. Let me see if I can pull up. Yeah, there's the counts, the first slide there. Also claiming that her First Amendment rights have been violated and equal protection claims. And a retaliatory termination under Title IX. So that's a case to watch as it moves its way through federal court. Doe versus Emory University. This is an interesting case under Title IX about the fairness of an investigation done on a sexual assault claim under Title IX. Both the district court and the 11th Circuit affirmed the dismissal of this case. Anyway, the student claimed that she was sexually assaulted by the male student. Investigation was conducted, and the male student claimed that the investigation was biased against him because of his gender, and because of that, he filed the lawsuit under Title IX. Following court precedent, this Doe v. Sanford case, the 11th Circuit illuminated that he didn't show, and this case was dismissed on a motion to dismiss. The allegations in the complaint were insufficient, so they crossed the line between discrimination based on his gender versus favoring the complainant. So there's a demarcation in the case law over that issue, and his lawsuit was dismissed. Rodemaker versus City of Valdosta School District. This is a Title VII discrimination case with a really interesting fact pattern. So what happens here is that there's two lawsuits, and this is a race judicata case. So he files, I call it Rodemaker 1, lawsuit 1, and he's a white football coach teacher who was terminated, okay? And there are apparently 5 black board members on the school board, and he claims he was discriminated based on his race and by being fired. In the first lawsuit, you see the claims he brought there, and he brought it against the board itself. And so in the first one, that one got dismissed, Rodemaker 1. He sued the 5 board members, and then he refiles it, and he doesn't appeal that first dismissal. In Rodemaker 2, he brings very similar claims against, he this time included the school board as a defendant. He leaves out the claim for Section 1981, but otherwise the claims were very similar. And this case was dismissed based on race judicata. So number 1 was dismissed for failure to state a claim. Number 2 is dismissed for race judicata. And I'd give you the law there on race judicata. Number 3 is the key one. It prevents bringing claims when the same parties or their privies were involved in a previous suit. And this case has a long discussion on whether school board members are privies of the school district and all that kind of. So if you're got a case like this, you can look at that, but it's a helpful discussion of that. Anyway, the result was these cases were so similar that race judicata barred, and the 11th Circuit affirmed the dismissal of the case. AW versus Coweta County. This case kind of amplifies. I did last January a presentation on Section 504 as it relates to students and employees. And this is an student application of that. This involves some pretty bad facts. A student was sexually abused or abused in a classroom. She sues. The school district files a motion to dismiss, basically saying, oh, she can't pursue these claims under Title II of the ADA because she's got no damages, and the trial court granted that. Wow. The 11th Circuit is going to reverse because she's got other damages other than emotional distress, but essentially Section 504 in Title II, you can't seek emotional distress damages. And apparently that's what the complaint had a lot in it. But the 11th Circuit reversed to see if there's other types of damages she's pursuing in the case other than that. Legislative update. One of the big ones, and I'm sure you're probably getting phone calls on it too, is the paid parental leave. The legislature and Governor Brian Kemp increased the number of weeks to 6 weeks now. And so they get more leave. You get into some tricky scenarios if someone exhausted their parental leave, and this wouldn't affect July 1. So if someone has a qualifying event, say like in January, February, they exhausted it. And then now they have their buckets full again, but they got another 3 weeks. If they took 3, now they got, so they would get more leave. So there's lots of talk about how to handle people who've exhausted the leave, but now they are now asking for the same event. I didn't see anything in the statute talking about these qualifying events, the time frame in which the qualifying event has to happen. So if they have the qualifying event, they're still your employee, they have the hours in their bucket of leave, then it's probably going to be okay. They have some additional notifications that are required for the school district. Everybody has to be notified of paid parental leave. Probably going to happen in a handbook and annually thereafter. Yes, sir.
And guys, can we have any questions repeated from the microphone so the folks
Yeah,
on can
I'll
hear?
try to repeat as well as I can.
Thank you.
So the question is, how does anybody enforce paid parental leave? And would it be done through an 1160 hearing? That's OCGA 20-2-1160 or a mandamus. I don't see any enforcement mechanism built into the statute. I don't recall any in there. So you don't have that. You don't have like somebody overseeing it. I mean, one avenue would potentially be a breach of contract. And of course, that would involve an 1160 hearing. Perhaps some discrimination type of claim. But yeah, your enforcement of that statute, I think, is going to be at the employee's discretion. Of course, you know, you always go down to HR and have them talk it out, but that may not resolve things. Because it is paid parental leave, therefore you're getting that money as part of the leave, so that would be part of the breach. Everybody got pay raises. It's kind of where I am running out of time. Teachers got pay raises. State employees got pay raises. What to watch for? Actually, the 50, I forgot to change this number 1. There are 504 regs. They're out. They came out May 1. You make these PowerPoints so much in advance that you forget the correct stuff. There are 504 rules. HHS promulgated those in May. They went into effect July. Here's one of the, on the Supreme Court docket, it's another discrimination type claim under the ADA. What is a qualified individual? Probably be back here talking about that one in a year. And the DOJ has some rules out on what is a qualifying website under the ADA. Probably want to check that out. They have a final rule on what qualifies. All of our clients have these. And the Department of Labor came out with a new rule on what is a what's the salary basis for an executive administrator or professional employee. I point this out because that salary is increasing. And a lot of our employees are teachers who might make a salary a lot less than that. So you need to go back when the effective date is January 1. So probably a good idea to check the job descriptions and see if you got them exempt or not based on their salary. And that's all I have for me. And Dan Murphy's up next. Thank you.
Well, good afternoon. Um, Thank y'all for coming. If you were unfortunate enough to endure the January edition of this presentation, I talked to y'all about the proposed regulations that came out last August. And so the main idea today was to kind of update the final regulations, what might be different, and then a little bit more, hopefully thinking about how we might implement all this. So this a little bit of a sequel to, what we talked about in January. And I was talking to my kids this week about getting ready for this presentation. Of course, they don't talk to me what they're doing. They're 15 and 14, right? They fine, good, whatever. You never know what's going on with them. But I was telling them what's going on with me. So I'm telling them I'm doing this presentation, and it's an update on a presentation I gave in January. My son, who wants to be a pilot, says, "Oh, so it's like a sequel, like Top Gun Maverick." I said, "Well, yeah, it is kind of like that." He says, "Daddy, are you Tom Cruise?" Well, now that you ask. And then my daughter, who's 14, just gives me this, death-defying look. She goes like, "Nah, you're more like Gru from the Despicable Me series." So right back in my place. But anyway, so this will make more sense if you have seen or were there for the presentation back in January. But we got the final rules. Were they up there when I just did this? No. This? Yeah.
Let me go grab some.
There are 14 more slides. I haven't touched much, so I don't know what I could have screwed up. But so this statute, it's meant to, the idea was it's meant to fill in a gap between the Americans with Disabilities Act, which, famously said, in general, pregnancy is not a disability, Title VII, and the Pregnancy Non-Discrimination Act, which is interpreted by the Supreme Court, didn't really require a lot in terms of accommodations for employees and drew a fairly high bar in terms of, what the employers could do before something was considered discrimination under that law. And I think, the Family Medical Leave Act, which of course talks about childbirth, really only talks about leave, not, things that we might do so an employee can stay at work. So it's kind of like if the ADA and the Pregnancy Non-Discrimination Act got together and had a child, and then subsequently that child had another another child with the Family Medical Leave Act, you get kind of a statute which kind of pulls them all together, or tries to. Okay. All right. Thank you for that. All right. So maybe it's just that one slide. Maybe it's just the second slide for some reason. But so the summary of what the law requires is the school must provide, or the university must provide, a reasonable accommodations to a qualified employee's known limitation relating to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. absent undue hardship on the operation of the school. So you see a lot of ADA-like language in the statute, right? And that's the postcard version of what we're talking about. So a couple of things that we can immediately, kind of settle on is, we're talking about something medical in nature, with regard to, the employee. There's not a bonding component. This is about what's medically going on with the employee who's pregnant or who's had birth or given birth. There's not a bonding component to it. And it is specific to the employee. So it's not about a spouse or anything like that. So it's about this one employee and their medical condition. So a little bit about what's happened along the way. So we got the proposed rules out last August. I think that's supposed to say June 27th. There was, no. The Texas decision dealt with the statute. The February 27th decision in Texas, where all federal employment laws go to die, is, I believe the issue in that case was whether or not Congress could vote by proxy and whether or not the statute itself might be unconstitutional in the way it was passed. So, all right, so that happens. Then in April, the final rules come out. In June, you had two different cases going on. This is kind of a little bit of foreshadowing of what we'll do with our Title IX presentation here in a minute, where we'll talk about how all the different courts have blocked those regulations. In June, in one case in Arkansas, judge said that a coalition of attorneys general didn't have standing to challenge the final regulations. That was dismissed there. In Louisiana, the same month, another judge did block the abortion-related provisions of the final rules, so arguing that the Department of Labor had exceeded its authority as set forth in the statute by saying that abortion could be a covered event as far as the regulations under the PFWA go. And I guess I didn't remember the actual published date of the Loper case. So all of this preceded Loper. So the challenges to regulations, going beyond the statute are probably, more formal now, than they were at the time of either the Arkansas or the Louisiana decision. But as far as I know, as of yesterday, the final rules for the rest of us have become effective. So we'll kind of walk through the different major components of the statute and just talk a little bit about what these mean, and then maybe raise some of the questions related to that. So it covers qualified employees. So who are qualified employees? So the first part of this definition, this is our ADA definition, right? This is an employee who, with or without reasonable accommodation, can perform the essential functions of their job. That's pretty much ADA. Now, we'll come back to this in a second for the point below that. The statute is, this is in the statute and the regulations. There's this second type of qualified employee, which is where you see this statute kind of going beyond what either the ADA, FMLA, or Title VII had ever provided before. So the employee can also be considered qualified even if they cannot perform one or more essential functions. And it continuously, we're talking about one or more essential functions. So we don't want to get stuck into a situation where we're just talking about, one function. If the employee is just asking for an accommodation with regard to, or if they are asking for an accommodation with regard to 2 or 3 different fundamental aspects of their job, is that somehow not on the table? And it's clear they're talking about more than one if necessary. So it's one or more essential functions. And that employee can still be considered a qualified employee if, and then there's these conditions attached, if the inability to perform that essential function or functions is for a limited time only, not permanent, and may extend beyond the near term. We'll talk a little bit more about what we know there. And the essential functions can be performed in the near term on a case-by-case basis. Generally, with regard to a pregnant employee, we're talking about, can be performed within 40 weeks. That's the idea there. For non-pregnancy related conditions, and so remember, we're also talking about childbirth and related medical conditions. So for non-pregnancy covered conditions, the near term is not necessarily presumed to be 40 weeks. It may go beyond, and in fact, in the comments, they talk about it may go up to 6 months. They even talk about it may go beyond 6 months. And this inability to perform the essential function can be reasonably accommodated. If all those things are true, then the employee can be considered a qualified employee, even though they can't perform several essential functions of their job, which, that's contrary to what we're used to thinking about with the ADA. Many of my ADA cases have wound up getting resolved because the employees kind of fall into this trap. The more, unable they are, based upon the more severe their medical conditions, allegedly are, they put themselves in this box where they are admitting, I can't do the essential functions of my job. There's nothing you can do to allow me to do the essential functions. They really want someone else to do the job. And of course, the ADA doesn't require that, right? So that's, if you're talking about category one, that's still workable. But here, they can go further and say, like, I can't do essential functions A, B, and C, but I'm still qualified because, based upon these timelines, they can be performed in the near future, and you can reasonably accommodate them, that kind of thing. So that's on the table. Then we have, well, as with regard to that last, point here, when is it reasonable to accommodate the essential function, accommodating the employee's inability to perform the essential function? And you have 4 different variables that the regulations set forth. These are 4 different alternatives. It's a temporary suspension of the essential functions, but the employee is working and doing all other aspects of their job. So this category of qualified employee, they're continuing to work. All right, we're just talking about, what accommodations will allow them to do so. Their essential functions are not going to be performed now, but they want to stay at work because they want to keep getting paid, right? And so they're continuing to work. They're doing the non-essential functions of their job or other essential functions of their job, but not the 1 or 2 that they're claiming they can't. Or they perform the remaining functions of their job and some other or added functions, but say they still want to work. Or they temporarily perform another job entirely if we have a vacancy for which they're capable and qualified to perform. Or they're assigned to light or modified duty. Those are kind of the 4 different ways we would go about deciding whether or not the essential function can be reasonably accommodated. So you got the folks who, with an accommodation, can do all of their essential functions. Then for the folks who can't do 1 or more, what's the kind of the analysis for whether or not it's reasonable and for how long to accommodate them? They're still working. Presumably they're working full time, but there's different ways we might structure that. And in the regulations, the department talks about there's 2 types of qualified employees, and that's what we just said: the ones who can do their job with an accommodation, and the ones who can't do the essential function and need, one of these 4 different arrangements. I think in reality, there's really 3, because as a part of this first group of folks, they talk about if leave is the accommodation, whether the employee can be reasonably expected to perform the job at the end of leave. All right, so this is the employee who's not working. In the first case, we were talking about somebody who, with an accommodation, they can do all their essential functions and they're at work doing the job. In the second case, we're talking about somebody who can't do the essential functions, but we comply with one of those structured arrangements, but they're still at work doing, most of their job or another job. They're still working. This category here, folks, they're on leave. They're not doing their job. And the accommodation is they get to go on leave. Now, this part of the regulations, I think, is something that could be challenged because the statute doesn't talk about this. The statute doesn't talk about some type of leave here as being a reasonable accommodation. Now, we know the ADA does allow for that, but this statute didn't. This is something the department put in here. So to me, this is a little bit squishy because the statute doesn't talk about this. The statute doesn't talk anything about what are the rules for when they come back. Is there some kind of like FMLA, right to reinstatement? The statute doesn't talk about that because the statute doesn't talk about leave as an accommodation. So this is a little bit of a kind of a square peg scenario. The first 2, I think, make, a lot of sense, and we understand how they're going to work, or at least have an idea of how they're going to work. This one, there's a lot more gray around it. All right, so those are who the qualified employees are. They say 2. I say really 3 different categories of qualified employees. So what's a limitation? So this is going to sound ADA-like, but we're talking about a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. This is different, though, It's different than the ADA and different than the FMLA. And this didn't change between the proposed and final rules. There's not an objective floor here in terms of the severity of the physical or mental, whatever it is. It doesn't have to qualify as a disability, doesn't have to qualify as a serious health condition. There's no objective standard that you're supposed to be, that we can look at and say, well, this is bad enough, so you are now covered, or this isn't that severe, so you're not covered. They talk about other things making the same point. Condition can be minor or episodic. They specifically say it doesn't have to be covered by the ADA. No specific level of severity required. Evaluated without mitigating measures, same as under the ADA, right? I think as a practical matter, the way this and this is going to be a struggle for my HR folks because they love forms and they love objective standards. I think the way this works is it's almost kind of circular in that any physical or mental fill in the blank that the doctor says requires the accommodation is on the table. And that's going to drive my HR folks nuts because there's nothing, you can't go to the book or go to someone else and say, is this really that bad? Well, if the doctor says it's bad enough to require this accommodation, then almost by definition, it is, because there's no other standard to measure it against. So that they're going to all have fits about that, but we'll have to learn how to live with that. But that's a little bit about, the medical piece here, the nature of the limitation arising out of pregnancy, childbirth, or related medical condition. Now, when is it a known medical condition? Most of this carried over from the proposed rules. The employee doesn't have to come to us and use any magic language, right? It can be the employee, a representative of the employee. They went on what is new in the definition of, well, what's a representative of the employee? We knew you can have like spouse, family members, friends, healthcare providers, all that stuff was in the proposed rules too. It didn't have to be the employee themselves. They added in the final rules a union representative, which is probably not a huge issue for a lot of us, but in other parts of the country, you might see a lot more of that. Then they talked about, what is the communication? Who does that go to? Is that required? That goes to HR? And the answer to that is no. It doesn't have to go to HR, at least not directly. The idea here is that most of these accommodations are things that the employee should be able to bring up with their immediate supervisor. And the idea here is that most of these things should be simple, quick, and easy, and y'all ought to just figure it out at the school or in the building or at the work site. And this shouldn't become a big deal. It shouldn't become a drawn-out deal. And it should lend itself to kind of expeditious resolutions. One of the things that's in the background here, this whole statute, it's really pushing us toward, the quick, informal resolution of these issues. One of the big things in the background here is because the nature of pregnancy, accommodating whatever the needs of the employee might be is extremely time sensitive. Right? We can't have, a 4-week process to decide whether or not you're covered or not. Right? The nature of the condition doesn't really allow for that. So we need to move through this whole thing more rapidly as far as the Department of Labor is concerned, and I think Congress too. So the communication by the employee or their representative can go to their supervisor, their manager. It can go to HR. They did add this notion about anyone who regularly directs the employee's tasks. I think another way of getting at who's the person that they go to for everything else. I'm going to be out tomorrow. Well, they tell their immediate boss or supervisor that, that kind of thing. They want these things dealt with as quickly and at the lowest level possible. We can't require that this notice be in writing. There's no specifically. Now we can confirm it. We want to create the paper trail and kind of confirm what's being requested and the basis for all that. But we can't have that requirement. The verbal request by the spouse or the adult child, that is sufficient to put us on notice. And the communication only has to reference the limitation. The initial communication doesn't have to start putting on the table what might be the accommodation needed here. It just has to let the boss know that, so-and-so, is pregnant, or after so-and-so had birth, or since the birth, there's a medical or medical or psychological condition. And so they can't supervise students. They can't lift more than 20 pounds. They can't stand for 6 hours, whatever it is, to the limitation. That's enough. That's enough. So I went through a lot of I don't know, concern over, how in the world am I going to train all the frontline supervisors who work with all the school districts that I represent, to be sensitive to this. You can't tell them to go to HR. You can't tell them to put in writing. How are you transportation director? How are you supervisor of maintenance? How are you going to make sure you know all of this stuff? Because if you handle it wrong and it never gets to HR, by the time it does, it'll be too late to fix it, potentially. So I got real worried about that. And then when I'm dealing with a new legal issue, I kind of go through stages of understanding. Sometimes initially I'm very confused and I have to go back over and like kind of figure things out. And then sometimes at the end of the day, I think, well, all right, maybe this isn't as bad as I thought it was, or maybe this wasn't as complicated as I thought it was. It takes me a while. But so as I kept worried about this piece of this, particular statute and the compliance angle and the fact that all my frontline supervisors need to be able to handle this, I've kind of moved more toward the idea, and I'd be interested to see if y'all think this is realistic. Really, what we need that immediate supervisor to know is if you have an employee who's pregnant or giving birth, and if they indicate that they can't do something, or they're struggling with something, or they need something different, just call us. That's all you might need to know. You don't all need to sit through a 30-minute training on all the ins and outs of the statute. You just need to know, to recognize that pregnant or employees just giving birth, there's something they're struggling with or something they're asking for help with, call HR. And we'll figure out, what the accommodation may need to be. But they don't need to kind of necessarily solve all of these problems on their own. I don't know. Y'all can let me know if you think that's workable or not. The theory behind the statute is they are going to solve these problems at the frontline level. That's what I don't think is realistic. Now, a lot of the presumption here is that these accommodations are easy. And, a lot of what they think is needed is something like, well, just if somebody needs to sit and they can't stand, just let them sit. There's a rule that the teacher has to walk around the classroom, but this teacher can't do that. They need to sit for 20 minutes every period or whatever it is, then just let them sit. Or if they need breaks for water, or they need to carry water with them, they need more frequent bathroom breaks, if they need to be able to have a snack. That is the list of basically the presumptively reasonable accommodations that the department thinks is most of what should come up here and most of what the frontline supervisor should easily be able to address. In terms of global frequency, that might be right. Of course, those aren't the cases that get to us, right? People probably don't call their lawyers to ask about whether or not so-and-so should get to carry a water bottle. It gets to us when the accommodation is more impractical or has a bigger impact on, the rest of the building. That may be our bias. That may not be the actual. Yeah, well, that's not one of the, well, no, I'm sorry, it is. That is going to be one of the accommodations for which we can't require documentation other than a self-attestation. That's going to overlap a little bit with the Pump Act, but yes, we can be accommodations to allow an employee who's lactating to pump is one of the accommodations covered under the law, for sure. All right. So, all right, who's a qualified employee? What's the limitation? How do we know about it? What is covered by pregnancy, childbirth, and related medical conditions? So pregnancy and childbirth, all of these in the regulations, they kind of have somewhat of a laundry list of all the things they propose to cover. And I didn't just copy those here. There's a few things here that are summarized. Under pregnancy and childbirth, for instance, it does cover, past, current, potential pregnancy, fertility treatments, use of contraception, things like that. for related medical conditions, it covers a much broader array of things, including, as controversial in the Louisiana case, abortion, and a laundry list of other related medical conditions. And the idea here is that the connection between whatever that might say, you're looking at depression. Right, so there's not an objective standard of, the pregnancy has to be the sole proximate or driving cause of the depression. Not nearly that high bar. It's a much lower threshold. Matter of fact, you can argue there isn't really a threshold. Previously diagnosed conditions which are exacerbated by pregnancy or childbirth, you're covered. Any relationship, they talked about related to pregnancy. So there's not necessarily, is it the primary cause? Is it the initial cause? There's none of that. It's just any relationship between pregnancy, childbirth, or related medical condition and the physical or mental limitation, and you're in. So it's a very broad, and it's meant to be a very broad, if you want to think of it, kind of a loose, low bar under what's going to get, captured under the scope of, what's a limitation. All right, so we have pretty easy to get accommodation or get, medical situations covered under the statute, but it's not like FMLA in that it's an entitlement. It triggers this ADA-like interactive process where we decide whether or not there's a reasonable accommodation. Now, there are certain things that are considered pretty much, per se reasonable, and that's the water breaks, the breaks for food, the sitting, the standing, those kind of things that we talked about a minute ago. Otherwise, you're going through the ADA-like interactive dialogue where you're deciding whether or not there is a reasonable accommodation. The statute says it's the same as the ADA. The regulations pretty much copy that, although they did add remote work as an example of what might be a reasonable accommodation in the Pregnant Workers Fairness Act regulations. That isn't listed as a reasonable accommodation under the ADA regulations. So there's some further specific examples of things that they want to put on the table here. The part-time modified work schedules and the reassignment to vacant positions, that's straight out of the ADA, right? I don't have a ton of times that we actually, do that necessarily, but those have always been part of the ADA as potential accommodations that we have to consider. The notion of these breaks, whether or not it's water or bathroom breaks, assignment to light duty. And I think that's a little bit of a thing with the department, because if you were here for the original Top Gun presentation, we talked about how one of the motivating factors here behind the legislation was there was a Supreme Court case where the court, drew a pretty narrow circle around, what similarly situated employees, how they were treated, and didn't agree that a light duty accommodation was reasonable for a pregnant employee, even though the employer had provided light duty for workers' comp, because they said those aren't similarly situated enough. And so the department's position is, well, we've changed that now because light duty is clearly a potential accommodation. And I think that's, because we know that decision was one of the inspirations for the law, that's probably something they're going to be looking out for. So if we have employers, I have some clients that will say, well, we don't have any light duty positions. Well, you might want to think about not necessarily making that a hard and fast rule. We at least need to consider it. Even if your answer is 99 times out of 100 we don't, you might want to at least consider it, in theory, that we could have a light duty accommodation. Telework is something that, we all had a lot of experience with in the last couple of years, sometimes not for the good. One of the things that's come out of this under the ADA, and then we'll certainly apply here, is that some of my clients will admit, and they won't put it on paper, but they'll admit, in the hallway, that, that some of these back office jobs in the business department and the finance department, yeah, those people can pretty much do their job from home if they just come to the central office once a week. Now, nobody could that can't happen, right? Because the central office suffers from enough, prejudice as is. If you go up there and there's nobody there, then, there'll be a revolt. But a lot of those back office jobs, a lot of the times, they can be. And so we've gotten into where, somebody from payroll has this medical whatever it is, and they want to telework 2 or 3 days a week or half days or something like that. And we have to consider that And sometimes we have this track record that shows, well, when they were teleworking all the time, it did fine. So then it's harder for us to say that's not reasonable now, right? And so that's kind of what's on the table here. Now, for a lot of our, student-facing positions, if you're a teacher or a professor, we also have a lot of track record that says that didn't go so well. It was doable, we survived, but it wasn't very effective most of the time. And then you have this notion of, and this is where now we have the love child of the ADA and the FMLA and the pregnancy going beyond, where we're saying suspending an essential function is a reasonable accommodation. That's definitely one of the newer aspects of this. So how does this interactive process and the documentation process work? So, okay, generally, start with our ADA process, right? Then we've got these things, though, that where it's pretty set that we're gonna need to make these kind of accommodations for the issues with lactation that somebody mentioned a minute ago. If the need for the accommodation is obvious, and they talk about how in many cases, whether and when an employee is pregnant will be obvious. Now, be careful with this. Be careful with this. Because I remember as a young, stupid man, I once thought that a lady was pregnant. And I proceeded to ask her about this. And I turned out to be in error. And I still have the lead in my hand for where she stabbed me with a pencil. So be careful about making that assumption. I need to see the P-test now before I'm going to go speak first about anything along those lines. But they think it's obvious in Washington. If the employee's already provided sufficient information about the fact that they're pregnant, if the accommodations on the short list, that is, they need to carry the bottle of water, bathroom, those kind of stuff, no documentation, we are pretty much going to need to accommodate that, the lactation issues. And then one of the things they added between the proposed and final rules is this: if the accommodation is already permitted under existing rules without any added documentation. Well, you kind of wonder, well, why would they need to add that, right? I mean, if we already do it for other people without requiring documentation, why would we fight about that in this case? I don't know. Some of the principals I work with, okay, maybe we do need to write that down, because sometimes people kind of get bowed up about certain things and they don't want to cross a certain line. But for the most part, you would think that's unnecessary. So the documentation that we can request, it's very case by case. It's very factually specific, case by case. Is it reasonable now? And it's limited to only what is necessary to confirm the physical or mental condition and that an accommodation is needed. They can provide that documentation from any healthcare provider, and there's a long list of who that can be. Now, they emphasize repeatedly in the rules that, you don't have to require documentation. Matter of fact, in many cases, and you can't have a specific required form. So they don't want us to do that. Right? They want us to say, oh, welcome back from your maternity leave. Oh, you need a little help with this, whatever this essential function of your job is. Let's have a dialogue about it, and let's figure out a solution. They don't want, the paper trail. They don't want the delay of, we need a note from so-and-so explaining this. There is no provision for a second opinion. No FMLA rule here. There is no fitness for duty, sending them to our own doctor. That's not a part of this. But if we are going to proceed down the path of requiring some kind of documentation, then there's a list of things that you get out of either the comments or the interpretive guidance that we're not supposed to do. And so these are just kind of, all traps to be wary of. So, we can't require the medical diagnosis, because a lot of these limitations, remember how low the bar is, these physical or mental limitations. They don't have to be disabilities or serious health conditions. It doesn't have to be, a diagnosed medical condition. It can just be, that somebody is vomiting. That's an example that specifically comes out of the comments, things like that. And so you don't need to go send them to the doctor, get a diagnosis, wait on the form from the doctor. When the doctor doesn't send it, we don't have to follow up with the doctor saying we need the form back. You're not going to play that game here, or they don't want that. They want us to move more quickly through this. We talked about the condition, doesn't have to be caused by the pregnancy. It's just related to. So it's very very open-ended in that regard in terms of what's the connection. I thought this was interesting. They specifically talk about, and if you do require documentation, it doesn't have to be from the employee's treating physician or treating whatever. I don't know. I'm not sure who else it's going to be, but what this makes me wonder about is, all right, it can be from anybody or anybody who qualified as a healthcare provider on that previous list. Does it even have to be specific to the employee? Or can the documentation be something from a medical textbook that says, pregnancy frequent results in blah, 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 blah? Doesn't have to be from their treating physician. We can't use a specific form. They talked about, there was a debate about whether or not they should develop the forms like we have for the Family Medical Leave Act, which are not required, but a lot of us use them or a version of them because we're comfortable that, okay, these are defensible, right? Well, these are legit. We're not stepping outside of any lines by using the department's own forms. Well, they didn't want to develop forms here because they're basically said, we're afraid you'd use them. And as we've made clear throughout these, regulatory comments, we don't want you to use forms. You need not require forms. And did we mention you can grant leave or an accommodation without documentation? But if you insist, then these are all the things you can't do. And so we're not going to give you a form and have you all run out and adopt it because we don't want you to use forms. We don't want you to require documentation. But if you insist, you can develop your own, but you'll have to be careful, that you can't just transplant the FMLA form, for instance. You're going to have to, be very cautious about that. Now, a lot of my HR people will probably push me to develop a form because they love forms. And the idea of kind of moving through these things on a case-by-case basis, well, it depends. What kind of note did we get? They even talk about, I think this is in the interpretive guidance, an email from the doctor can be enough. I don't know a lot of doctors that give out emails. They seem to be very sensitive about that kind of stuff, but that's how informal and minimal it could be. But a lot of the HR departments, they're going to want forms. They're going to want some kind of process to follow to administer this thing, and maneuvering through this one case at a time. Is this reasonable? Is this condition close enough? That's going to drive them crazy. And I think that's not completely unintended. I think part of the theory here is that, look, if we make it really hard to be strict, you'll probably be really lax. And that's what we want, right? We want you to grant the accommodation, figure out the solution, grant the leave, and just do it quickly and not make a big deal out of it, and not drag it out. I think that's the kind of the operating theory here. They talked about, should we be concerned about fraud? And they pretty much said, yeah, you should be concerned about fraud. Next problem. And they gave us no authority to actually do anything about that. You can't do no second opinion, none of that kind of stuff. No confirmation or verification that the note even came from whoever the note claims to have come from, anything like that. In terms of what the reasonable accommodation rule looks like, you can see almost all the changes. The changes are what was added in the April final rules are leaning in the direction of you don't have to have documentation. The rule is all about limits on the documentation you can get. And it has to be really narrowly focused on confirming that there is this physical or mental condition that arises out of, very loosely, pregnancy, childbirth, or related medical condition. And that's it. Now, if we want to say no, which of course is not what they want us to do, but if we want to say no, we're going to need to be careful. I will be very careful the first time I have a client that wants to push back based on the paperwork, because in so many places, the rules lean against the idea of requiring documentation and then limit the documentation we get. The idea that we're going to say, no, we can't do this because your note didn't say whatever, to me, doesn't feel like very solid ground. It's not where I'd want to die on, the hill I'd want to die on necessarily. We'll talk, in a little bit more about the biggest defense here to something the employee is wanting accommodated, I think, is going to wind up going back to our ADA and back to our undue hardship standard, which is incorporated in this act. That's the limitation. We don't have to agree to a reasonable accommodation that would pose an undue hardship. And I haven't had a lot of ADA litigation, but in the cases that we've pushed back on, and those are the 5 factors there on the right that you're supposed to, consider whether or not the hardship meets that qualification, is the one on the bottom about the impact on the school or the campus or the department, those kind of things. That's been the one that's been most useful to us. And I think in this particular environment might be more promising for a client that wants to push back. A lot of clients I've got right now, we're having real issues just with meeting minimal staffing needs. And so an accommodation that would require someone or that would allow someone, either to go out on some other, on a leave when they'll have another entitlement to leave. There's no PPL, there's no FMLA, but they're wanting some kind of leave under this law, or to suspend an essential function when we can't find anyone else to do that job. Is that going to have an impact on the operation of the facility? I think I can sometimes get somewhere with that argument. Now I can see, I can see the other cases coming down the road, which we've probably all had these over the years, where we have the teacher who's pregnant and we have the student who's violent. And, how do we accommodate that? And that's on the table here, right? If in terms of managing the classroom and, dealing with that student, is that part of the teacher's job descriptions? Probably is. Is it an essential function? Probably is. But she has an argument now that, not performing that essential function while continuing to stay in the classroom could be a reasonable accommodation. Does that mean we have to add a parapro into that classroom to temporarily perform that essential function? It's on the table. It's on the table. Now, one of the interesting things about this impact, this is true in a lot of places, but whenever the big part of the analysis is what's the impact on this school or this department, and I think that opens us up to be able to argue, very specific facts. If I've got a classroom where there is no one else who is qualified or we can't find anyone else to do that job, then I have some evidence of impact. Now, depending on the labor market and depending on what kind of classroom that is, maybe depending on where my client is in the state, that argument might be different, right? And so I can make a better case for that sometimes. In other situations, not so much. And so to me, that's all this stuff about whether or not they have a qualifying condition, of mental or physical limitation, very fact specific, very case by case, what kind of accommodation are we going to have to, consider and perhaps provide, very case by case. I think they added that in one of the rules we just looked at. It's very case by case situation, which is going to be hard to deal with. And the issue is you have to spend too much time dealing with it, just grant it. And then, that's kind of what they want us to do. But the fact that the undue hardship thing can be very case by case to me is our chance to push back and say, well, we don't have to do it here because, so it's not, I don't think necessarily going to be, we always have to grant that accommodation because sometimes the answer no can vary based upon the facts too, not just whether or not the condition is a sufficient limitation or something. Mm-hmm. Sure. Yeah, I think it's on the table. Oh, I'm sorry. So I think the question Alan asked was, in terms of, putting different possible accommodations on the table, the employee or their representative, can also play an active role in proposing, well, this might be an accommodation or a workaround or a manner in which that, what the school would initially say, well, that would be unduly burdensome or an undue hardship. Maybe there's another solution, that solves that. I think that's part of all what the interactive dialogue is about. They do talk about, if there's more than one accommodation, at the end of the day, of course, it's the employer, who has the final decision on that. But the employees in this particular scenario, in the interpretive guidance, they talk about, well, the employee's preferred accommodation, should be given primary consideration. But at the end of the day, yes, the employer has the final choice. If there's multiple accommodations that might work. Yeah, they really didn't want that to be the answer, but I think they felt constrained. Um, in the case of in the qualified employee scenarios, I have the F1 employees. These are the ones who, with an accommodation, can perform the essential functions of their job. And then this is just reference to the code sections. The F2 employees, these are the ones who can't perform the essential functions. They want to work, but they need the essential functions suspended or delayed. And so then what's an undue hardship there? And so we have some specific language about that. So it's everything we just talked about in terms of, what the regular undue hardship factors are, including the impact on the facility, the school, the department, the building, and these other issues and these additional factors. And that's the length of time, whether there's other work for the employee to do, the nature of the essential function, including how frequently they have to perform it, whether we've accommodated other employees with a temporary suspension of these functions in the past. That's tied in with the light duty stuff. If we have, because our workers' comp carrier has pressured us into letting someone come back from a workers' comp injury and putting them in a light duty position that we didn't really want to have to do, but we did it and we survived and it worked out, then that becomes somewhat precedential for, well, why can't we have a light duty assignment here? And then whether other employees, temps, or third parties can perform the work. So that, doesn't mean the answer to suspending the essential function is always going to be yes. But these are the things that we're supposed to kind of run through in deciding when the answer is yes and when the answer is no. And it seems like the temporal aspect of this is significant. There does seem to be some thinking that, well, I mean, we could possibly accommodate suspending the essential function for a week, but we can't do it for 6 weeks. And so, beyond the first week, it's no longer reasonable for us to do that. It would be an undue hardship at that case. And that's a legitimate defense as long as we have the facts to back it up. And that's something that we're permitted to require. If we're going to we're going to get documentation. We're not just going to automatically agree to whatever the request is, but we're going to solicit the documentation, require the documentation, the time of the requested accommodation, the duration, the expected duration of that is something that we can include in that documentation. All right. That was not everything about these rules, but that was hopefully a useful summary of the final rules. And I hope I zeroed in on the things that might be more important or relevant for us as we try to start implementing this. We're supposed to have been implementing this, right? It's been effective for a couple of months now. So good luck. Let me know if you have any questions and bring it over to Ms. Sonia, I believe, right?
Great. Thanks so much, Santa. Definitely your stages of understanding resonated with me as we go into Title IX and those regulations, which of course, as we were all, those of you who have dealt with Title IX or dealing with Title IX in your practice, of course, on top of the fact that we're trying to go through those and assess what those mean for our practice, we have been dealing with the litigation and following that. My name is Sonia Salas. I'm also a partner with Gregory, Joel, Calhoun, and Rogers. And I'm going to talk to you guys a little bit today about Title IX. First of all, talk a little bit about the litigation that is facing those new regulations, and then talk a little bit over the 2024 regulations themselves that presumably at some point in the future, we may be looking at implementing within our schools in this state. So first of all, talk a little bit about the status of that 2024 rule. So sorry, it's tricky to see up here. I have the same bar that you guys do. So looking back at the Title IX regulations, just a quick kind of overview of where they started to get to here. I guess somebody will yell at me if I'm not close enough. First of all, of course, we have the Title IX of the Education Amendments was a 1972 law signed in actually June 1972. That said, so we have the law passed by Congress, signed by the President in 72, that actually went into regulations in 1975. There was a lot less than we dealt with once we got into 2020, and the Title IX regulations then, but did give us this idea of a Title IX coordinator and a grievance process. Again, a lot less detailed though than what we see in the subsequent regulations. From there, 2011, we had US Ed provided specific guidance documents regarding sexual violence in Title IX. We move forward into, and that would be under the Obama administration, move forward to the Trump administration and his US DOE. And we have a 2017, they rescind all of that guidance. They put out some interim guidance and they say, by the way, we're moving forward into the rulemaking process to address Title IX and sexual harassment. So we get we get the notice of proposed rulemaking, so the potential rules in 2018. Those were actually officially released. The final rule for the 2020 regs was released in, May of 2020. For all of us that were practicing in education law at that point, we remember that Title IX was not on the forefront of most of our minds as far as the practice of education, K-12 or higher education. We were trying to figure out, can we safely, have teachers and students in school? If we can't what's the bigger risk? Them contracting COVID in school, or for instance, special education sphere, having students who can't necessarily be served as effectively in a home setting coming into the building or trying to be served at home. So that was, we were in the midst of all that COVID craziness. And by the way, we have these 2020 regulations that had some very specific grievance processes in place, and those were effective in August of 2020. We have, under the current administration, a new notice of proposed rulemaking came out in July 2022, and almost 2 years later, in April 19th, 2024, we got our Title IX regulations, our 2024 regulations. It would be supplanting the 2020 regulations. Also note, I skipped one. In April of 2023, we also had the notice of proposed rulemaking, for Title IX and athletics. The expectation when that was released is that those regulations would be released in their final version, along with the 2024 Title IX, more general, if you will, regulations that dealt with sex-based discrimination and sexual harassment. That did not happen. A lot of commentators theorized that might have been an effort, since there was an expectation that the athletics rules were going to be particularly controversial, to kind of save, if you will, the 2024 regulations from challenges. Obviously, we're starting out with talking about where we are in the legal landscape. So if that was an effort to kind of make them less litigious, does not seem to have actually been the reality. Those athletic rules have not been released in their final version, so that is still pending. And of course, we have our 2024 regs. What has been released had an August 1st, 2024 effective date. So we have our April release, and then begins the flurry of legal challenges. They begin 10 days later. Georgia actually, along with in the state of Alabama versus Cardona, led that. I think there were at least two, if not, yes, so 3 of the suits, and then one the next day were filed. So we were, I believe, time-wise, the first part of the first suit to be filed, but one of 3 that day. But in all, we have a total of, there's 10 different cases nationwide, 7 that dealt with the states, the total 26 states that challenged the Title IX 2024 regulations, seeking stays of the rule or preliminary injunctions. So again, state of Alabama versus Cardona, what was very interesting for those of us who are practicing in Georgia following this is that as we began to have, district court after district court began to rule on these requests for injunctions and issue preliminary injunctions. Again, to Randy's point, presumably we ended up with 3 other states, 4 total states in Georgia, in a district court in Alabama, assuming that was going to be a more conservative and favorable venue for the requests that the states were making, that the U.S. Department of Education be enjoined from enforcing these rules. That is not what happened. This district court of Alabama became the outlier and the first and only district court to date to actually refuse to grant the preliminary injunction. So we'll talk about what that looks like in a moment. But yes, that was an exciting roller coaster. We kept getting closer and closer to go day and trying to read the tea leaves, thinking, well, it seems unlikely that in the 11th Circuit will be the outlier. We already are outlier, on gender identity issues when we have with our Adams decision going the opposite way. So we finally get a ruling on that on July 30th. that, again, surprisingly, we are the outlier. The district court said, no, I'm not going to grant this preliminary injunction, at least not at this point. And then July 31st, at this point, I believe this one was we got the ruling from the Court of Appeals at 4:30 p.m. The day before the rules were to go into effect. We got this administrative injunction on the rules. As you can see, a couple of these, so we have at least 3 of the challenges have made it up to Court of Appeals. So at the 5th Circuit, the 6th Circuit, and the 11th Circuit, and the 5th and 6th Circuits actually have gone on. We'll talk about that a little bit more, in part up to the U.S. Supreme Court. So, but to start with our case, state of Alabama versus Cardona. So this case was Alabama, Florida, Georgia, and South Carolina. Another interesting thing to see as you follow these cases is there are, I believe it's 7 states total who have actually joined in challenges outside of their home jurisdiction. In most of those incidences where we have states outside of their home jurisdiction, they are in jurisdictions that would not necessarily be favorable to the request for injunction based on the precedent that is within that circuit. Again, we were in this state of Alabama case. The Northern District Court of Alabama was the first federal judge to reject an injunction request and let the Title IX rule take effect. So on July 30th, we have this ruling saying, yes, we're going to move forward. Everybody's, gearing up. Okay, August 1st now. We've got a couple of days before this is go. They did say that the plaintiffs had failed to clearly establish they were entitled to the extraordinary relief. The judge did say that it is possible at later stages that we may get there, but said what you've showed here, we haven't had oral argument, is not sufficient for this extraordinary relief of granting of a preliminary injunction. So the same day that we get that ruling from the district court, the plaintiffs immediately file an appeal of that decision to the 11th Circuit Court of Appeals. So that's filed that afternoon. I believe, again, this was because I do remember time specifically because this was such a quick, little bit of a roller coaster. I believe this decision from the District Court of Alabama came out around like 11:30 on the 30th. And by, again, so they make this quick request for an appeal. And the 11th Circuit Court of Appeals by 4:30 on July the 31st granted an administrative injunction, put a briefing schedule and said that we are going to administratively enjoin the rules from becoming effective tomorrow. So, but then we also have yesterday, always before you present on a case, make sure you check the docket. Fortunately, I did check Pacer yesterday evening and realized that yesterday, on August 22nd, the 11th Circuit Court of Appeals issued a second order granting the motion for an injunction pending an appeal of the district court's denial of the request for preliminary injunction. So that is when you deal the district court's opinion, that's like 120 something pages total. There's a lot to digest there. The administrative injunction is just like a 1-page order. It says, hey, we're going to grant an administrative injunction. We're going to allow you guys to file briefs, and this is what the schedule looks like. And there's more like a 30-page, I believe, 20 to 30-page decision from yesterday where they granted the request for injunction. They did note that in granting, and they being the 11th Circuit Court of Appeals, did note that in granting the injunctive relief that was requested, they were maintaining the status quo along with every other federal court, including the Supreme Court, who had ruled on this issue. So to that point, to go back a couple of days in time, on August the 16th, 2024, so what is that, a week or so ago, the Supreme Court did consider appeals brought by the 5th and 6th Circuit cases. Those ones affected Louisiana, Mississippi, Montana, Idaho, 10 states. I won't go over them, you can read them. But affecting 10 states. In this case, the U.S. DOE had requested an emergency application for appeal of the preliminary injunctions. What the U.S. DOE actually requested in these is, I believe I get it. Yes, so they essentially, they said, okay, fine, we'll give you that we have these challenge provisions. They weren't actually requesting the Supreme Court allow the challenge provisions to go into effect. However, they did say a lot of this rule is not challenged. For example, changes to the grievance process, the language regarding pregnant workers and pregnant students. So can we move forward with that? Can we move forward at least with implementation of the unchallenged? The U.S. Supreme Court ultimately decided no. They rejected that. And you see here's an explanation of the challenge provisions, expansion of the definition of sex discrimination to include discrimination based on gender identity. de minimis harm standard. The second one of the big concerns raised by the plaintiffs there is this de minimis harm standard will prohibit schools from preventing transgender individuals from using sex-segregated facilities aligned with gender identity. And then finally, the definition of hostile environment harassment as applied to discrimination based on gender identity. One of the concerns that was raised by the plaintiffs related to that is this concern there was going to be First Amendment implications, for example, with requiring other students or teaching staff to use students' preferred pronouns. So essentially, USAID said, okay, fine, we'll give you we're going to have to continue and argue those out to a decision, but can we move forward with the other stuff? U.S. Supreme Court said no in a 5-4 decision. The court was unanimous on the issue that whether the stay of challenged provisions was proper. They all agreed those need to be stayed, those need to, go through the entire process. The split was whether the injunction should have applied to the remainder of the 2024 regulations. Of course, the 5 had it that it was going to apply, but then there were 4 dissenting judges who would have gone on ahead and let those unchallenged provisions of the 2024 regulations move forward in those 10 states. And you do have some language here from the majority. It's only a several-page opinion, but it does talk about the fact, and this is they took the reasoning and the language of the lower courts, and their explanation here was the new definition of sex discrimination, which of course does refer to gender identity, is too intertwined with and affects other provisions of the new rule. Therefore, the 3 provisions are not readily separable. So it's too intertwined. There's no way for us to pull this part out and say that the rest of it can move forward. So just some of the numbers as far as where we are in all of this litigation. There were 10 total complaints filed across the country. Again, 7 states filed outside of their home circuits. So with South Carolina, for example, joining Georgia and Florida and Alabama and their litigation in Alabama. At this point, we have 26 states total where enforcement of the 2024 rule is enjoined. We have at least 3 Court of Appeals rulings, as well as the U.S. Supreme Court ruling. We have 24 states plus DC where the 2024 regulations went into effect on August the 1st. So they are under the 2024 regulations. There are roughly 400 K-12 schools and 700 institutions of higher education where those institutions are subject to an injunction. And that does include some of these schools and institutions that are located in those 24 states where enforcement has not been enjoined. And that is based on the Kansas versus U.S. Department of Education case. In that case, the Moms for Liberty, Young American Foundation, and Female Athletes United were also plaintiffs that joined the states in that case. And when granting the injunction, in that case, the district court judge went a step further and said that come up with a list of schools throughout the nation where you have these clubs, and all of those are compiled on a list that is actually put out by the U.S. Department of Education, that the enforcement is also enjoined in those schools as well. I'm out for water. Tickle. So here's just a handy little map of where the Title IX regulations are blocked. These were very interesting to follow when we were going through the series of rulings, as you had, of course, where there were pending challenges, where there are final decisions. At this point, all the orange is we have, perhaps final is the wrong word, but where there are preliminary injunctions that have been ordered halting the enforcement, at least for now. This is a statement from the U.S. Department of Education's site on Title IX. You can see there's a nice little link to it there, but it's an informational page about the Title IX 2024 regulations, and it does note all the states where enforcement has been enjoined. And this was an issue that was, up in limbo. There were practitioners that were concerned about what are we going to do in these states where it's enjoined? What are we under? USDOE did at least go ahead and give us the fact, look at that final sentence. They did officially say, if you're in an enjoined state, then we're still under the 2020 reg. So move forward under those for now. So where are we now? Sorry. U.S. Department of Education is barred from enforcing any portion of the 24 regs in jurisdictions and schools affected by the injunctions. So if we're in Georgia, we don't have to worry about those lists, and there are Georgia schools on those lists, so it could matter later if the status quo changes. But for now, we're one of the states with that is enjoined, and we're going under the 2020 regulations and watching. Now, that said, schools may choose to adopt policies that comply with the 2024 regulations at this point. However, they do need to ensure that those policies don't conflict with the 2020 regulations or state laws that might otherwise have been preempted. Certainly for our higher education university institutions, an important difference there, that would be an issue with going ahead and moving for the 2024 regs is the 2024 regs at the higher ed level do remove that requirement of a live hearing. However, 2020 regs require that. And one thing that, as far as trying to be proactive with as quickly as things are changing that we have worked with our clients on is, looking at what has to be in policy versus procedure and really parsing that out. There is some helpful guidance from the US DOE regarding this is the language that needs to be in policy and the non-discrimination notice, and it's not a ton of material. So putting kind of the bare minimum, what needs to be, and this is take it for what it's worth, but what I think is really helpful to take that bare minimum, this has to be in there, this is required under your capital P policy that's going through your local Board of Education for the K-12 institutions, and then all of those much more detailed grievance procedures, having those separately in your written procedures, which gives you a lot more flexibility, as these things keep coming out and changing, to change those and amend those as needed, as the landscape potentially continues to change. So with all of that said, I'm going to talk you through a little bit of the 2024 final rule. Apologize for all the need for water. Some kind of got allergy stuff going on. Some tickle just hit me while I'm talking. So the background, again, issued in April. Enforcement started in August 1st, 2024, except for in 26 states and the 1,100-ish schools where it's enjoined. Application. So this is an interesting wrinkle of the 24 regs. The 2024 regs, where they are in force, only apply to incidents that occurred on or after August 1st, 2024. So it kind of puts you for once you're under the 24 regs, assuming we are in the future, it kind of puts you, and you're going to have some dual enforcement, dual procedures. Again, a reason to have, the lowercase p procedures in place, because you're going to have training and you're going to have procedures on both, unless you come up with, and there is the option of coming up with procedures that cover both. But assuming you don't, then you potentially have different obligations in place, because any incidents that occurred from August 2020 through July 31st, 2024 are going to be under the 2020 regs. So they are still subject to those requirements. And that doesn't matter, and that's regardless of reporting date. So of course, just because assuming in the future we are in the 2024 regs, regardless of when it is reported, what you're looking at is the actual alleged incident date. And then the length of, there's a lot to digest. The length of the regulations, or the final rule in total, was 1,500 pages, with 57 of those being the specific regulations themselves. So one element of the 2024 regulations is that they really do have a lot more flexibility in the process. They're a little bit less prescriptive than the 2020 regulations were. One of those differences is the option of having a single investigator and decision maker model. For those of us who are familiar with the 2020 regulations, really segments up the process, which can be a challenge for schools in coming up with, different training and different individuals or groups of individuals who can essentially perform those functions to different levels. So the new 24 regs do say that those can be the same person. It also says, again, with the 20 regs, you couldn't have the Title IX coordinator in some of those roles. The Title IX coordinator can be in those roles. You still do have to have a separate appeal decision maker and informal resolution facilitator, though, even under the 24 regs. At the higher ed level, one of the major differences, of course, again, was removing that requirement of live hearings. Under the 2020 regs, it's required at the higher ed level. It's optional at the K-12. Certainly, I don't know everyone's practice, but I can say none of my clients were opting into having live hearings over sexual harassment charged with K-12 students. One thing, my practice really is K-12, but one thing I've certainly heard, from the higher ed practitioner standpoint is, although the 24 regs have removed that requirement of live hearings because of the requirement still for the Q&A, question and answer, transcribing, a lot of higher ed institutions are going to have to look at what does that look like? How difficult is that to facilitate? Is it worth moving away from the live hearings? Or is it going to be more cumbersome just because of figuring out how the lay of the land looks with you're doing this transcribed Q&A or type process? Big difference, formal complaint under the 2020 regs, you are looking for a written formal complaint to actually initiate the grievance process. So if you have, you have notice and you have a meeting with the Title IX coordinator and they're going to provide supportive measures. However, the formal grievance process begins once you have that actual written complaint. The 2024 regs, again, more flexibility. They said, no, actually, this can be written or oral. As long as it can be objectively understood as a request for the recipient to investigate and make a determination. So there's going to be additional training requirements, and you're really going to have staff well trained because, again, just a lower bar for us to be put on notice as school districts or higher ed institutions that we need to initiate that process. Another difference with the written notifications, the 2020 regs, once you have that written formal complaint, not only is there a requirement of this written letter going out to a respondent as well as the complainant, but there were also very prescriptive, specific things that needed to be in that written notification. 2024 regs do not specify that it has to be a written notification. It could be an oral notification. Now, working with my districts, I would still suggest, and I think it's pretty good counsel, to go ahead and put that in writing just to ensure that you have the documentation for the steps that have been followed. However, oral notification could be sufficient under 2024 regs. Application. So one of the differences is the Title IX 2024 regs are going to apply to conduct subject to the school's disciplinary authority. This is going to be an extension of the jurisdiction versus the 2020 regulations. For example, one of the limitations of the 2020 regulations that was interesting is it had to happen in the US. With this change, potentially this could be international, because a big question that usually came up, or at least the scenario, the example scenario would be, well, if you have an international field trip. Well, at this point, international field trip, that's going to be, a school-sponsored event that would still be subject to the 2024 regulations. And also, again, a disciplinary extension. So if it would be subject to the school disciplinary authority, when we're working in the K-12 sphere, we know, the public K-12 sphere, we have off-campus misconduct, for example. If you have that kind of behavior under state law that's potentially chargeable as a felony and causes a disruption or potential danger in the school environment, we extend, or the legislature has extended districts' authority and jurisdiction. So that would be an example of the kind of conduct where, because legislature extended it at the K-12 level, that kind of conduct would potentially be, again, reached by the 2024 Title IX regulations. And then sex-based hostile environment also talks about in the 2024 regs the downstream effects of out-of-school conduct. So even where you can't necessarily address the out-of-school conduct, it doesn't, it's not subject to the school disciplinary authority, potentially having under Title IX to address the downstream effects that are happening at school based on the conduct. So when we deal with the 2020 regulations, they were really focused on sexual harassment. The 2024 regulations go further. They look at sex discrimination, of which sex-based harassment is going to be a part of that within this larger category of sexual discrimination. And then that's going to include based on sex stereotypes, sex characteristics, pregnancy-related conditions, sexual orientation, and gender identity. So de minimis harm standard, one of the things that has really been one of the contentious things that has gone into the litigation and the request for preliminary injunctions is this de minimis harm idea. It says, in limited circumstances, and the regs say, in limited circumstances where Title IX permits different treatment or separation based on sex, a school or district must not implement differential treatment by means that subjects a person to more than de minimis harm. And then we have, next page? Yes, okay. So, and then we do have, the regs do speak specifically about religious and athletic exemptions to the de minimis harm standard. Specifically the athletic exemption, the expectation being that this is what's going to be addressed later when presumably US Ed releases the final rule for the Title IX athletic regulations. So there is speculation, well, this means that there is going, this is going to go into the bathroom facilities access question. And actually US Ed released a pointer for implementation document in late July, and it does explicitly say, talking about the de minimis harm standard again, For example, if a school maintains sex-separated restroom facilities, it must not prevent students from accessing the restroom consistent with their gender identity because doing so causes them more than de minimis harm. So we have that directly, from US Ed. There's a couple links here. The first one is just to the pointers for implementation documents, that I'm pulling that from. And the second one is to a just general US Ed page. They do have some useful resources on that. A video. I was excited to watch that video. The 2020 regs, there was like a 30-minute video that at least kind of walked you through it. I saw the newer video they had released for the 2024 and thought, okay, good. I'm going to have a sit down. It's like 3 minutes long. So don't get too excited. It's not a ton of information, but there is a video. There's pointers. One of the really helpful documents on there is, I forget what it's called, but it's all on this page. But there's a document that even says, hey, you don't have to use this, but here is a sample of a non-discrimination notice for the 24 regs that's acceptable. Here's a sample policy language, and here's a sample grievance process that you can use to craft yours. So those are some really helpful tools to the extent that you are moving forward with the process of trying to, prepare to be compliant for these 2024 regulations that may be coming down the line for Georgia and other states that are currently enjoined from enforcement. I'm out of time. All right. I will go through these last slides really quickly, get you out of here. Sex-based harassment, just some quick pointers on some updates under the 24 regs. Quid pro quo on the 20 regs. This quid pro quo has to be an employee conditioning a benefit on sexual conduct an employee on a student. On the 2024 regs, it can be an agent of the school district. So it's an employee, but it can also be another person. So that could be something, for example, like potentially a student tutor who's providing tutoring services. So just think about the fact that that's going to be potentially broadened. Hostile environment harassment that's again, another one of the major areas of contention for those who have raised concerns with 24 regs. It's broadened. It's conduct that is subjectively and objectively offensive and is severe or pervasive. And it limits or denies a person's ability to participate in or benefit from the education program or activity. So there is an expansion there. Dismissal, main point here is under the 20 regs, you had permissive dismissal and you also had mandatory dismissal. 2024 regs, all dismissal is permissive. Title IX and students with disabilities, 2024 regs add in their requirement of a consultation with members of the IEP team or 504 team when you're dealing with an investigation that involves a student with disabilities, potentially, engaging one of those teams, looking at, for example, do you need is an MDR implicated if you're looking at emergency removal? The process, I think we've pretty much gone through all of this earlier when I was talking about the fact there's more flexibility. One point here is with the 2024 regs and the 2020 regs, all procedures were in 106.45, 2024 regs. 106.46 is specific to higher ed, and that does deal with the live hearing or Q&A requirements. Access to evidence under 2020 regs, we have to provide access to evidence. 2024 regs, an accurate description would also be sufficient. The investigation report, that requirement is removed under the 2024 regs. Pregnancy and related conditions, spectrum of processes and events can include pregnancy, childbirth, termination, lactation, related medical conditions and recovery, requirement to provide reasonable modifications. Training, so just the important thing under the 2024 regs is there is a requirement for annual training of all employees on the 2024 regs. And then there is it builds. So you have to have this, base level training for all employees. And then of course, additional training for people who are involved in the Title IX process itself, from the coordinator to decision makers to informal resolution facilitators. And thank you everyone for your time. Right on time. Oh, yes. litigator. Do you want to take that one?
You're presenting on Title IX. I don't want to step on your toes, Sonia. No, I don't know. Alan, I mean, I haven't seen the challenge in Georgia. You know, I guess people are thinking about it, and we may be seeing it now. So, I just haven't seen that type of challenge. We're so rule bound. You know, we follow the rules, and we think we satisfied all the due process that they're afforded, but obviously there are wormholes around that, and maybe these other circuits. I'll take a look at it. Well, we'll have to leave it here. That concludes our annual meeting, and thank you guys.